Hello, and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, have you or someone close to you considered suing your business partner? Sounds pretty scary. Well, if so, stay tuned. What's our topic today? The three questions business owners should ask before suing their business partners. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. On this episode of the podcast, we're tackling a tough reality for many entrepreneurs: suing a business partner. With over 70% of business partnerships facing disputes, from breaches of trust to financial disagreements, these conflicts can threaten your company's survival and your personal bottom line. Now, legal action is a big step, and getting it wrong could cost years and millions of dollars. And that's why we have David Milian with us. He's a seasoned litigator whose firm, the Milian Law Group, has fought for clients in federal and state courts, earning accolades like Florida's legal elite. Now, who better to have on the podcast than we're going to discuss, three questions business owners should ask before suing their business partner. And joining us from Miami is David Milian. David, great to see you.
Hello, Wayne. Great to be here.
Great to be. I'm glad you're here. Now, you and your wife Elizabeth decided to open your own law firm, the Milian Law Group. Before we get into all of our questions and comments, why don't you just tell us a little bit about the law firm, who you are, what you do, and what makes your firm so unique?
Sure. So between the two of us, we're both lawyers. We have a combined experience of over 50 years representing business clients. When they're facing some of their most important problems and decisions in the legal sphere. My wife heads up our intellectual property transactional practice, which is trademarks, copyrights, taking the brand throughout the entire process from developing the name and logo and then protecting it with the registration, and then all the way through litigation if there's a dispute between copyright or
70%.
trademark owners.
That number, when I was doing a little bit of my research for today's podcast, 70% of business end up in some partnerships end up in a dispute. That's a remarkable number.
It is. And so our firm is focused on litigation. My practice has been representing businesses. And we have what we call a concierge practice. We focus on the results that the business is looking to achieve. When they've come to us, it's because they probably are at the end of trying to solve the problem themselves. And so they need guidance from someone in the law that's been there, that's advised businesses, and that will be there 24/7 if they need it, because these disputes don't take a 9 to 5 role. They can happen anytime, and they really can disrupt a business if they're not, even if they're handled perfectly.
And we're going to focus on that today. Now, I got to mention this. When we were first getting to know each other, you shared some of your success stories as a litigator, and I found it really interesting. But I got to say this right now. The one case that sticks out the most, no offense to all your other successes there, David, was how you literally saved Christmas. Now, the reverse Grinch, somebody mentioned to me here earlier. And I remember you telling myself that if I ever had you on my podcast, I was going to have you tell the story about how you, David Milian, literally saved Christmas. So you have to share as much as you can, I guess, without compromising any confidentiality. Give us the 35,000-foot view of that story. It's quite interesting, actually.
Yeah, so the word literally there is doing a lot of work, Wayne, but it's you got the gist. I was approached by the family members of the author of the song Santa Claus is Coming to Town, which everybody knows. It's an iconic song.
No kidding.
The family, the author had a deal with the publisher, as most authors and musicians do, where the publisher would take hold of the rights to the song and then pay royalties over time. Under the copyright law, there's an opportunity at some point and different points where the author or the author's family, heirs, can get all the rights to the song back, no matter what their contract said when they signed it, years and years ago. So the family, looking at the statute, said, we want the song back. And the publisher hired a very sophisticated, well-heeled firm, looked at this and said, no, we read the law differently. We don't think you can get it back. We're keeping it. So, too bad. We'll keep paying you royalties, but we're keeping the song until the copyrights run out and it becomes basically public domain. So the family came to me and I looked at their problem and I filed a federal copyright infringement lawsuit. And in federal court, where I said and argued, look, the statute does provide them this right. It was a pretty novel case. There wasn't a lot like it that we could go on. Bottom line, 35,000 feet. We tried the case in state court. We went up to the federal district courts of appeal, and the publisher appealed that up to the US Supreme Court. And the decision affirming that the song rights all go back to the family, which is what we argue, came from the Supreme Court just before Christmas. So the saving of Christmas, that's how we tie it together. Plus, obviously, the iconic song.
Great story. Well, that is something that's a quite the accomplishment, quite a success story, and I think I would carry that around for a while.
Yeah.
Well done. Okay, so turning to the present, we're dealing as always. I talk about economic uncertainty. Let's try to find a period of time going back to ever where we don't have some level of uncertainty, but with the brand of uncertainty that we're having now in 2025, David, are you are you seeing the number of disputes rising because of, I will call it, financial pressure? Do you seeing any blips or increases, less, more? What are you seeing now in terms of the number of disputes that are coming across your desk?
So, in terms of partnership disputes, ownership disputes, I'm definitely seeing an increase in that. And it's, whether it's the uncertainty, it could be attributed to demographic issues. We have a lot of younger people wanting to start businesses, which is phenomenal. There are universities that offer majors in entrepreneurship, which I think is fantastic, but those are new things. And then we also have, demographically, our baby boomers who are after 35, 40, 45, 50 years in business with their partners and co-owners are viewing the world a little differently sometimes, and things are developing. So I think it may be a combination of the uncertain economic times we have plus some demographic issues, but I'm definitely seeing an uptick in those kinds of
So baby
disputes.
boomers are more likely to sue after, 20, 30, 40 years of being with the same partner. It's almost like the gray divorce in the business world, right?
Absolutely. These are very similar to family divorces. There's a lot of emotion. Families get involved from all sides. So yeah, absolutely. There is certainly that aspect to it.
I think, well, I know you would agree with this, that, a business dispute can drain the wealth of any family involved in the business. So the reason we have you here, Dave, is we want to educate and inform our listeners on how to protect their bottom line. So, and it would be fun if you don't mind. I know you told us a story about saving Christmas, but maybe you could tell us about a partnership dispute where you actually, or your strategy actually saved the client's business and overall and their wealth.
Yeah, so one that I can think of off the top of my head, and it's fairly recent. I had a client come to me, and he and his colleagues were participants in a company. They owned a percentage of a company, and the company's business was developing commercial property. So there was construction involved,
Mhm.
architects involved, but that was the business. And over the course of time, in the middle of their most substantial project that they had undertaken to date, it was discovered that the one of the managing partners had a relationship with one of the major contractors that was part of the development, and there were payments being made that seemed suspicious. And as the investigation continued, significant sums of money were being paid that did not pass muster. They didn't seem reasonable. There seemed to have been some, self-dealing going on. So this is the largest project. So firing the contractor and starting from scratch would have been a disaster, or it was perceived to be. The other business partner, who had a substantial percentage of the company and therefore technically could make a lot of the decisions, was denying everything. So I took them to court and I brought an immediate temporary restraining order, preliminary injunction, where we put all of this evidence up front in the first few weeks of the litigation. And that got the other side to a settlement where at the end of it, the payments stopped. The decision to make payments shifted so that my client's involvement was much more significant and oversight was much more significant. My client's percentage in the outcome was also increased to compensate for the levels of funds that were inappropriately paid. And the project continued and it was completed and it sold. So the business was looking like it was going to collapse through protracted disputes, possibly some criminal charges that could have been brought. And at the end of the day, we moved very quickly and we were able to, as I said, increase our client's position, oversight levels, and get the project completed.
And after that project was completed, did the business kind of dissolve and get sold off from there? I would assume that
So
partners
yeah,
probably wouldn't
so
be too
so
compatible after all of this what occurred.
yeah, the partners decided, to part ways and are each doing different things today. But that being their to date their most significant project, having letting that finish and be profitable for everyone, it was a springing board for both sides to split and go their own way and be successful separately.
Well, congratulations on that one. Okay, so we're discussing the three questions business owners should ask before suing their business partner. And so, David, why don't we get right to the questions? We're here.
Sure,
Get
let's
on
do
with
it.
it.
Let's do it. Yeah,
So, question number one, and these are from the perspective of the business owner, just to be clear, from the partners, we'll say from one partner versus the other one. So, question number one, what can I do so that my business doesn't suffer as a result of my decision to proceed with legal action against my business partners? And I guess that would be a huge question because everybody's worried about, going into this and ended up blowing up their business.
yeah. So, you've probably heard the adage, pain is inevitable, but suffering is optional.
Yeah.
So in any dispute with your partner, it's going to be painful. There's just no question about it, but suffering can be avoided. And really it's preparation. Immediately, if you think that there is a problem that is going to impact the finances and the ability of the business to continue smoothly, or even your psychological and emotional ability to continue giving it 100% to your business,
Mhm.
seek legal advice right away, and financial advice, because you're preparing for a dispute and you want early legal advice as to where this
Legal
could
and
go,
financial, not just
and
legal.
financial,
Agreed
because it's
100%.
going to it's going to be potentially financially taxing if you get into a dispute that isn't resolved quickly, and a lot of these do not resolve quickly. So
Yeah.
those are the two big things: be proactive, um, money up front to seek financial advice to make sure your books are in order, your finances are in order, a lawyer to make sure your documents are in order to at least assess what your rights are if you do go into a dispute, and that way you've at least anticipated where the case could go. You could even try to fix some of the gaps that the lawyer or the financial advisor see before you actually start the dispute, which would make it less suffering, less painful.
So I think in short, this not that I wanted the short version, but the short version is act or be acted upon. I think is probably the better.
Absolutely. You
So,
put it very well.
oh,
Yes.
thank you. So let's think about this a bit further. What proactive steps can a business owner take before filing a lawsuit to minimize disruptions to their operations? I think about like protecting client relationships. You talked about cash flow already. maybe having to set up a temporary management team, almost like a shadow government, if you will. I've heard this term the last couple of days, different format, obviously, but a shadow or temporary management team, or maybe even having outside, consulting stakeholders. Like what kind of steps would you see as being a wise to proceed?
Yeah, so there are a number of steps. First, as you say, what's your management structure look like? What do you see if you do get into a legal fight? How is the management of the business going to continue to operate effectively? Because you want the business to continue to operate and to be successful regardless. So really look at your management structure. Do an inventory of your documents. Inventory those documents because those are going to be key in any dispute. What those documents say, what those agreements say, they're going to be critical. So inventory them, make sure you have them in place, make sure you have them ready to give to your lawyer and to your financial advisor before you get into the heat of the dispute. Look at your employees. Are there any disgruntled employees or former employees who may, if they're sitting in court testifying, bias the case one way or the other, and what can be done, just to know that that's the case, so that your lawyer is fully prepared for that. As you say, once you get into a dispute in terms of management, you can always agree to have, depending on the voting power of the various partners, you can always agree to have an advisor come in, a temporary CEO, CFO come in, and in some cases where there's a dispute, one side wants independent management, the other doesn't, then you can file an action in court. And one of the things you ask for is to appoint a receiver, which is, a CEO, court approved, to come in and manage the business to while the case is proceeding, to make sure that operations continue, bills get paid, business goes forward, et cetera.
You know, you talked about having all of your documents in order, and that segues nicely into our second question. Today we're being joined by David Milian with the Milian Law Group. He's based out of beautiful Miami, Florida, by the way. Um, so question number two perfectly lines into from where we came from. So question number two is, my business partners and I don't have an operating agreement. I shudder to think of that, by the way, but how does that affect our business's ability to function and resolve our problems? And I bet you the obvious statement is it does.
Yeah, it does. So the levels of uncertainty that you have in any dispute, they're now exponentially increased because you don't have a document that has what do we do when we can't agree? What do we do when there's a deadlock in the management decision? What is how many votes, what percentage does it take to enter into a new territory for the business or open a new bank account? All of those things are part of an operating agreement, a good operating agreement. And if you don't have that, there's now all that uncertainty. And you may go on recollection and, well, this is how we always did it. But now that you're looking at a dispute, how you always did it may not be how the law will ultimately say you should have done it, or how it should be done in the future. So not having an operating agreement raises the level of uncertainty, and as a result, raises the costs, most likely, when you do go into litigation, because now you're left with the state statutes where you're incorporated, and those will define and provide the minimum definitions for how your business should operate, um, in the absence of an agreement to the contrary. And those, when there's a dispute, for example, if the 50-50 partnership and you can't agree on something and you're at deadlock, which means the business can't proceed, you now have to look to the statutes as to how to resolve that. And they're pretty draconian. You go into court and you liquidate the business. That's how you resolve the dispute. That may not be optimal. That may not be what you want. So clearly, having your documents in advance is preferable.
Just as a follow-up to that on not having an operating agreement, what have you seen as I will say the most common mistakes businesses make when they don't have an operating agreement and disputes arise? And I guess second to that is, what do you do to avoid it, to strengthen their case? I mean, I know it's a mouthful, but you know,
Yeah.
just from a
Yeah.
high level at least, maybe you could give us some insight.
Sure. So when they don't have an operating agreement, so oftentimes, particularly partnerships and businesses that have been in business for a long time, memories recede, and what one partner thinks the deal is very different or substantially different than what the other partner or partners think the deal is, to the point where I've had, this is real life stuff, a partner thinks that they are a 51% owner of a business, and the other one will swear on a stack of Bibles that they're 60-40 in his favor, in the other
Hmm.
side's favor. And so, what do you do in those situations? You have to reconstruct the capital contributions, reconstruct the history of correspondence between the partners, which just ups the costs, the uncertainty again, and the levels of anxiety that each partner has, because now, what one thought was, what they each thought was the actual deal, they just, neither one is in agreement as to it because of this dispute.
You know, uh, what ultimately ends up sometimes, and this we're going to hit in our address in our third question, is about you going to court. And I know you are a litigator, so it's not something that you're not afraid of. But as a business owner, the idea of ending up in court is not exactly the most exciting outcome. So this leads for our third question, which is, if we end up going to court, how long is it going to take to resolve our problems? And can we still resolve them without actually going to trial? David?
So yeah, absolutely. So you look at, in most major cities, where a business dispute is going to be filed. It's most likely going to be filed in the highest level state trial court or federal district court. And in most of those jurisdictions, judges are juggling between 1,000 and 2,000 open cases at any one time.
Wow.
So they're your referee. So to get them to call balls and strikes in your case when they've got 1,000 to 2,000 other cases, that's going to cause some delay, because in these cases there will be a lot of judge decisions before the final trial, and they have to be made. And so getting them teed up and decided takes time. So typically, to go to trial, 18 months to 36 months is not uncommon, and that's considered pretty standard. There have been cases that have gone on for decades. That's uncommon, and I won't get into any anecdotes, but had a case that I was brought in after it had been litigated for 17 years.
Good work.
And I was brought in on year 17, and by year 18, we had to try to a jury, settled and done. But that happens. And so you have to be prepared as the business owner that you're not going to file the lawsuit and the judge is going to suddenly call everybody in a week or two. You're going to tell the judge your story. A jury's then going to be impaneled and they're going to decide in an hour or two. That doesn't happen.
So other
It's a
than the
long
old,
process.
yeah. So other than the normal sort of gestation period of how long these things take, what other factors will often delay uh, partnership dispute cases? Is there in court? And is there anything that business owners could do to sort of push for a faster resolution, other than capitulating, of course?
Right. Yeah.
Give in.
Yeah, it's always so there are a couple things. So the first thing is, when the client comes to me, I have a conversation, and my one of my first questions, what do you want to have happen? What is it that you want to happen? And if it's a realistic goal, and I think it's realistic, then I will tell the client that. If it's something that I think is unrealistic, in other words, it's a remedy that a court just can't provide, or I don't think will be legally justified at the end of the day, I will tell the client that. So having realistic goals coming in, because if the other side, drops a settlement offer and it's close to your realistic goal, you've now cut short the process because you're going to resolve it, which answers the second question, which is yes, you can resolve, litigation once the case is filed, but not having that goal in mind. If you get communication from the other side and you don't really know what you want at the end of it, you're not going to resolve it. And it's just going to continue to be litigated. And
I think,
perhaps it should have been resolved.
yeah,
And
it
so
makes,
once we're in, yeah,
Mhm. Go ahead. No, go
once
ahead.
we're once we're in litigation, almost every trial court requires mandatory mediation with a certified mediator. And so that you can schedule that early on, but before you go to trial, a judge is going to make you go through it. That's another way. If you do an early mediation and the parties look like both sides want to try to resolve it, that's a way to do it. And it really depends on the clients. Are they ready to resolve this early? There's nothing that prohibits it. I've encouraged it in many cases where I think, both sides have legitimate positions. Let's push this to a mediation. A good mediator will then, do shuttle diplomacy between both sides in a room or in a Zoom room and try to get the case resolved. And so I've found success doing that early on when appropriate and where the parties are amenable to it.
I couldn't help but think while you were sharing there, and I almost interrupted you, and I apologize, about this case that went on for 17 years that you were brought in and you were able to resolve it within a year. So, not here to
Yeah,
toot your own horn,
yeah.
but was there circumstances that seems rather remarkable that a new set of eyes are brought in here and all of a sudden you get to a resolution, much more quickly with something that seemed to be going on literally for years and years and years. I mean, there has to be a different approach. There had to be some kind of a meeting of the minds.
Yeah, so when I got the case, I looked at it and it was a multiple 30 counts with racketeering, conspiracy claims, and just causes of action. And the businesses were still engaging in business. So every few months, some other thing would happen that would be added to another predicate act for, the suit. And so it was just never ending. Uh, I took a look at it and I surmised that it was in the client's best interest to really trim down this lawsuit and focus on the contract issues and the real estate issues because the primary asset of this business was a large piece of commercial real estate. That was really the dispute that was driving this. So I recommended coming in, dismissing voluntarily 90% of the counts and just focusing on the two areas that I thought were the most important and critical. The client agreed after I explained everything. And that allowed us to get in front of the judge with a much narrower focus where it was triable. And we were able to try it in 7 days as opposed to, it would have been 30 or 40 days based on the original suit. So that's how we were able to get it done in a year after I got involved.
Are there people out there you think they're almost like, what's the term I want? Chronic sewers. You know what I mean? They're just their first line of defense is always to litigate everything as opposed to I know I've heard stories of people like this in the past. Do you think that's still, do you ever come across people like that their first line of defense is just, well, I'm going to sue?
Yeah, and it's definitely, a psychology and how that person views disputes and how that person views how they've calculated the pluses and minuses of litigation. There are some clients who have gone through disputes and they say the last thing I want to do is file a lawsuit and litigate. And there are others who regularly say, look, this is what's happening. Let's sue. We're not going to resolve it unless there's a complaint, unless this person on the other side is shown to this is a serious problem, and now they're going to have to respond in court. So it's really up to it's the psychology of the business owner. I've
I
had
do.
yeah, I had a case, another anecdote, and this was an arbitration because the dispute, the operating documents required arbitration, but this was a 10-day arbitration. And on day 8, I'm there with my client, and we're walking back to the main room where the arbitrator is. And he's looking haggard because, these are long days and he's been on the stand for a long time. And he looks at me and he says, David, would you think that I am crazy if I tell you I just love this? And I looked at him and I said, no. It's like I would say you're probably in a 10% of people who would say that. That doesn't make you crazy, it just makes you pretty unique.
The beatings will continue until the morale improves.
Exactly.
David,
Correct.
you have what, 34 plus years experience fighting for your clients and business disputes. You must, we're always learning. What's the one lesson that you've learned that every business owner should know before taking legal action against a partner, and how would you apply it?
Yeah, so there are many things, but the one thing is, have an expectation up front. Understand what you are getting into. It's going to be a potential drain on the coffers of your company, and the calculus may be that that's a good decision to do. It will be a drain on your executive time with the business because your lawyer will be calling you and wanting things and needing things from you, and you will have to help. Hopefully, you have a staff that can help you, but if not, a lot of times it's you,
It could be a time
the owner
suck.
that's doing it. It will be, and so be prepared for that. And it's emotionally draining. We started off talking about analogies to divorce, and that's very emotionally draining. This is an emotionally draining process, so be prepared for that. Um, and if you are, then your expectations, at least as to those things, are managed, and you go into the dispute with that already settled in your own mind.
We got people who are listening in their cars on Spotify, on Apple, but we also and we have, obviously we have a video here. It's on the website, and for those who are watching, they see your contact information, your phone number, your email address, website. But if someone is listening in their car right now, they're driving around or they're not near a computer, what is the best way for them to contact you if they want to get a hold of you?
Sure. So email address is david@lawmilian.com. That's LAWMILIAN.com. The website is the Milian Legal Group, PLLC. Type that in and you will see our law firm webpage. And also our business phone number is 786-808-9736. Any of those ways will get you to us.
David, I cannot thank you enough for joining us today. Great guest. This is long overdue. I've been wanting to do this. So thank you for making time out of your day to join us, and for educating and informing us. I really appreciate it.
I had a great time, Wayne. Thanks for having me.
See you soon.
Yep.
David Milian joined us from Miami, Florida. He is partner with his wife at the Milian Law Group. Thanks, David.
Thank you, Wayne. Take care.
I look forward to bringing you the Three Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification of when our latest episode has been posted, please click on the notifications bell. Lastly, to schedule an online consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we'll see you soon.